Hello everyone, welcome back to Polity Daily Drill, and here are the 5 questions for today. First up, consider the following statements. Even after the dissolution of the Lok Sabha, the Council of Ministers does not cease to hold office. Second statement, the Vice President is administered the oath by the Chief Justice of India or any other person appointed by the CJI in that behalf. And number 3, the removal of the VP in Lok Sabha requires a simple majority. Now, the first statement is actually correct. Now, if you ask me as to where is this mentioned in the Constitution, of course, it's not mentioned anywhere. This principle is implied in the structure and function of the Indian parliamentary system, rather than being explicitly stated in a single provision of the Constitution. However, it also aligns with the understanding that the Council of Ministers is collectively responsible to the Lok Sabha, which is mentioned or enshrined under Article 75, Clause 3. Right? The Council of Ministers remains in office until the new Lok Sabha is formed and then a new government is sworn in, primarily to ensure that there is no administrative vacuum. Otherwise, there might be a possibility of a vacuum at the top. There is no PM to run the country for a few days. This arrangement underscores the principle of a sort of caretaker kind of government. In the meantime, till we have the elections and a new government. So, one is correct. Second one, the VP is administered oath by the President of India or any other person appointed by the President on that behalf. This is clearly mentioned under Article 69, which talks about the oath of the VP. So 2 is wrong. It's not CJI, but the President of India. Number 3 is correct. If you refer to Article 67, Clause B, it does talk about the removal of the VP, wherein the removal in the Rajya Sabha, where it is actually initiated, is done through an effective majority, which means the majority of all the then members of the House, whereas for the Lok Sabha, it has to be agreed to by the House of People. This means a simple majority in the Lok Sabha, effective majority in the Rajya Sabha. Hence, 3 is the right answer. This means for this question, C, only 2 would be the correct answer. Moving on to the second question. Consider the following statements with respect to the Parliament of India. Fourth schedule of the Indian Constitution deals with allocation of seats in the Lok Sabha and the Rajya Sabha. So we know very well that the fourth schedule contains information on how many seats are allocated to the states in the Rajya Sabha, not the Lok Sabha. So 1 is wrong. Now, where are these seats mentioned? If you claim that certain state has say 80 seats or 40 seats or 20 seats in the Lok Sabha, where is this information mentioned? This information is mentioned under RPA 1950, the very first schedule of this law. This is where this information on how many MPs are there from each state in the Lok Sabha or how many constituencies are there in your state in the Lok Sabha is mentioned. So 1 is wrong. Second one, as per the Constitution, the elections to all the seats in the Lok Sabha are conducted via direct elections. Now, all the seats would mean representation from states, right? As well as representation from the UTs. Now, when it comes to states, that is true. For states, it is mentioned very clearly under Article 81 that the election has to be direct. But for UTs, what is mentioned is that the election procedure will be decided by the Parliament by law. And nothing is clarified on whether elections for the UTs to the Lok Sabha will be direct or not in the Constitution. This phrase was important. Hence, the statement is incorrect. There is a law in the country. That law is called the Union Territories, UTs, Direct Election to House of People Act of the year 1965. As per that law, we do have direct elections to the Lok Sabha from UTs as well, but it is not mentioned in the constitution, making statement 2 incorrect. And number 3, both the Lok Sabha and the Rajya Sabha have representation from all the UTs of India. Now yes, for Lok Sabha, every UT has a representation, but for Rajya Sabha, sadly, only 3 UTs have representation. We have discussed a similar question earlier as well. So you would remember, I hope, that UTs of Delhi, Pondicherry or Puducherry and Jammu and Kashmir have representation in the Rajya Sabha. So 3 is incorrect. All 3 are wrong. Hence, the answer is D. None of the statements mentioned above are correct. Moving on to question number 3. Consider the following statements with respect to amendment to the Indian Constitution. Amendment of the Constitution is mentioned under the provisions of Article 368. It's extremely important. We have had plenty of questions on various occasions in the prelims from this topic. First one, such bills can be introduced by a minister only. Now this is actually incorrect. Why? Because constitutional amendment bills can be brought by any member, any MP of the House. Whether Lok Sabha or Rajya Sabha, whether you are a minister or a private member. So it is not just limited to the ministers when it comes to introducing such bills. One is wrong. The president can exercise his pocket veto in such a case. Now this is also incorrect, because through the 24th Amendment Act of 1971, it has been made obligatory, mandatory for the president to give assent to such bills. So there is no alternative, no option for the president to use any kind of veto power. He or she must give his assent. It's mandatory for the president to give assent to such bills. 2 is wrong. So far, more than 100 amendments have been made to the Constitution. This is of course correct. We have just recently made the 106th amendment to the Indian Constitution. We'll have a question from it shortly in a couple of days on the 106th amendment as well. So yes, we have made more than 100 amendments to the Indian Constitution. Third one is correct. How many statements given above are correct? A. Only 1 is correct. Moving on to the fourth question. Which of the following statements are correct? The Constitution of India empowers the Supreme Court to entertain a petition as an appeal, even in cases where a High Court declines to issue a certificate for that appeal. So I hope you know that whenever you want to move from High Court to the Supreme Court, under Article 134 capital A, you need a certificate of appeal from the High Court. Or else the case should be a very important constitutional matter, a matter of general public importance of larger interest, or it should be a case where the High Court has reversed a lower court judgment and has given you at least 10 years of jail. Otherwise, for smaller matters, you simply cannot go to Supreme Court. However, Article 136, which is the SLP, Special Leave Petition. Now, this article says that Supreme Court in its discretion, so there is discretion for the Supreme Court. So what can Supreme Court do in its discretion? Supreme Court in its discretion can grant special leave to appeal from any judgment, any sentence, any decree, any order, in any case, any cause, any matter which is passed by any court or tribunal in the country. So yes, even if the High Court does not give you certificate to appeal in Supreme Court, you can request the Supreme Court, file a petition in Supreme Court that Supreme Court, I feel the matter is very important. High Court has not given me certificate. please look into it. And if the Supreme Court feels like it, it might entertain your petition. This is called a special leave petition. Leave meaning permission. So 1 is correct. What about the second one? Special leave petition is a discretionary power. Yes, as I said, Article 136 says that Supreme Court may, in its discretion. Very clearly, a phrase has been used. So yes, Supreme Court might accept or might reject your petition. In fact, the rejection rate of SLPs is very high. 90% SLPs are rejected. So SLP is a discretionary power of the Supreme Court and cannot be claimed as a matter of right. Absolutely correct. So both statements are correct. Hence the right answer is D, both 1 and 2. And the last question for today, the fifth one. Consider the following statements about the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989, the SCST POA Act 1989. The Act aims to prevent the commission of offences of untouchability against the members of scheduled castes and scheduled tribes. The Act specifically defines what constitutes atrocities against an SC/ST individual, and the Act prescribes punishments only for non-SC/ST officers who willfully neglect their duties towards SC/ST individuals. So the first one is wrong. Why is it wrong? Because the Act aims to prevent the commission of offence of not untouchability but atrocities. Why? Because for untouchability we have a separate law. So it is only meant for atrocities. For untouchability we have a separate law called PCRA, the Protection of Civil Rights Act 1955. Originally called the Untouchability Offences Act, later on renamed. So this law is meant to punish for atrocities, not untouchability. Second one. Now second statement is actually correct because there is a very specific definition of what would mean by atrocities. Section 3 of this law provides for 30 different types of atrocities. For example, if you attack, assault an SC/ST person, if you occupy SC/ST land, or if you try to dump something obnoxious in an SC/ST person's house, if you force them into eating something obnoxious, etc., if you try to blacken their face, insulting Dalit icons. So there are 30 different types of atrocities defined in the particular law. So 2 is correct and statement 3 is also correct. The Act prescribes punishments only for non-SC/ST people. So if an SC/ST person approaches an officer and the officer deliberately, willfully, knowingly neglects to perform his duties towards an SC/ST person and that officer is a non-SC/ST officer, then that person will be punished with minimum 6 months of jail to maximum 1 year of jail. So 3 is also correct. So 2 and 3 are correct, 1 is wrong. How many statements given above are incorrect? Only one statement is incorrect. Right answer is A, only 1. This brings us to an end of our discussion for today. That is all for me, guys. We'll meet in the next video. Till then, that is it for this video. Jai Hind.